Good morning and good afternoon. I am Akmal Azad, Director, Bangladesh International Arbitration Center, BIAC. Distinguished participants and viewers, it is our pleasure to organize today's webinar jointly with the United Nations Commission on International Trade Law Regional Center for Asia and the Pacific, UNCITRAL RCAP, based in Incheon, Republic of Korea. Today's theme is Regional Perspective of UNCITRAL ADR Instruments on Ease of Doing Business in Asia and the Pacific. To start with, I would now introduce Head of UNCITRAL RCAP, Ms. Athita Komindr, and request her to deliver the welcome address. She is head of the United Nations Commission on International Trade Law Regional Center for Asia and the Pacific, UNCITRAL RCAP. She has over a decade of experience in the fields of international trade and economic law, arbitration, multilateral dispute resolution, and the rule of law and development. Prior to joining the United Nations, Athita mainly advised and worked with numerous Thai agencies, including the Thailand Institute of Justice, the Thai Ministry of Science and Technology, the Thailand Arbitration Center. She also worked for the Thai Ministry of Commerce in Bangkok and Geneva, representing Thailand in bilateral, regional, and multilateral trade negotiations, WTO dispute settlement, and treaty drafting. Admitted to the New York Bar since 2002, Athita has experience in both common and civil law traditions in the public and private sectors, and holds degrees from Harvard College, Georgetown University Law Center, and Harvard Law School. Over to Madam Athita Komindr.
Thank you very much, Director Akmal, for that very kind and long introduction. Allow me now to share my screen. Is it there in full screen?
Yes, it
Is
is.
it there in full screen? Okay, just the slides, is that correct?
Yes.
Okay. All right, thank you very much. BIAC executive officers and colleagues, esteemed speakers and guests, greetings from UNCITRAL RCAP in Incheon, South Korea. My name is Athita Komindr and I head RCAP. Please accept our special thanks and congratulations to the Bangladesh International Arbitration Center on successfully organizing its 13th webinar despite the recent lockdown. It is an honor for me to deliver these co-welcoming remarks and provide an overview of how UNCITRAL instruments make it easier to do business in the Asia Pacific or AP region. UNCITRAL is an intergovernmental body established by the United Nations General Assembly in 1966 with the mandate of promoting the progressive harmonization of international trade law by preparing legislative standards in various fields of commercial law, including international commercial arbitration and mediation. UNCITRAL texts are negotiated with the involvement of a variety of states representing different legal traditions and levels of economic development. This helps ensure that our texts are widely acceptable as offering solutions appropriate to diverse jurisdictions. RCAP is UNCITRAL's only regional center and is located in Incheon, Republic of Korea. We opened our doors in 2012 with the support of the South Korean government to carry out UNCITRAL's mandate in approximately 60 jurisdictions in the AP region, working with government officials, the judiciary, legal and business experts, and academia. In addition, RCAP plays the leading regional role in carrying out UNCITRAL's technical assistance and capacity building activities, including in the areas of ADR. As background for today's discussions, since the early 2000s, the World Bank has published a series of annual studies measuring the regulations that enhance the doing of business and those that constrain it, and presents quantitative indicators on such regulations that can be compared across 190 economies, from Afghanistan to Zimbabwe, and over time. 12 areas of business regulation are covered, including the focal point of today's webinar, enforcing contracts. Contracts form the basis of day-to-day business transactions. However, while most parties execute contractual obligations in good faith, disputes inevitably and frequently arise, as you well know. There are various means, of course, for resolving disputes, and litigation is usually often the last recourse. Alternative dispute resolution, including arbitration and mediation, complements the traditional court system and helps foster a legally enabling environment that facilitates trade and investment. It provides more flexible, informal, and confidential means for parties to resolve differences, and the outcome is likely to be more amicable and reflective of the dispute and thus preserving of the business relationship. In addition, ADR helps relieve judicial backlog, thereby enhancing access to justice for the disputing parties, as well as public stakeholders, promoting SDG, Sustainable Development Goal 16. Within the Asia Pacific region, both the World Bank's Doing Business Project and since 2009, the APEC, or Asia Pacific Economic Corporation, Ease of Doing Business Initiative, based on the World Bank's Doing Business Project, are dedicated to how jurisdictions may assess and improve their regulatory environments to make it cheaper, faster, and easier to do business. Enforcing contracts, including the adoption and implementation of UNCITRAL arbitration and mediation instruments, are essential components in this regard. Since 2011, UNCITRAL has been supporting the Korean Ministry of Justice's APEC Ease of Doing Business project on enforcing contracts, aimed at improving the legal environment for enforcing contracts in APEC as well as non-APEC economies. South Korea's own experiences showcase how legislative reforms built on international legal standards, including UNCITRAL's, along with efforts to build awareness of private international law instruments to facilitate cross-border trade and investment, enhance ease of doing business, and foster effective enforcement of contracts and efficient settlement of business disputes. In this regard, UNCITRAL RCAP is grateful that Director Changwan of KMOJ's International Dispute Settlement Division could join us today to share South Korea's practices that may be adopted in Bangladesh's efforts to enhance and further improve its global ease of doing business ranking. As the latest doing business scores indicate, An improvement in the enforcing contracts indicators, along with others, could improve Bangladesh's overall score. In this regard, Bangladesh may wish to consider adopting legislative reforms based on recent UNCITRAL instruments on arbitration and mediation. For example, Bangladesh may wish to consider further revising its arbitration legislation based on the UNCITRAL model law on international commercial arbitration, with amendments as adopted in 2006. As RCAP legal expert An Nam will be speaking on that topic shortly, I will not go into the details, but would simply note that as of April 2021, this month, legislation based on the model law has been adopted in 85 states in a total of 118 jurisdictions. Recently enacting Asia-Pacific jurisdictions include Bahrain, Bhutan, Fiji, Myanmar, Mongolia, Republic of Korea, and many others. Bangladesh may also wish to consider joining the United Nations Convention on International Settlement Agreements resulting from mediation. Like the New York Convention, the Singapore Convention on Mediation strengthens respect for binding commitments, inspires confidence in the rule of law, and ensures fair treatment in the resolution of disputes arising over contractual rights and obligations. The convention is off to a remarkable start, having already entered into force only a little over a year since it opened for signing. As shown by the growing number of signatories, UNCITRAL's latest treaty is acceptable to states with different legal, economic, and social systems, with over half of the 53 signatories and 4 of the 6 state parties hailing from the Asia Pacific and South Pacific. Singapore, Fiji, Qatar, Saudi Arabia, and the other 2 state parties are Belarus and Ecuador. I defer to RCAP legal expert Jenny Wheat to provide more details on the convention later today. To further facilitate cross-border trade, particularly in the area of sale of goods, Bangladesh may also wish to consider UNCITRAL deal-making instruments such as the CISG, which for 40 years has been providing a modern, efficient, and neutral legal framework for all aspects of international sales contracts, from their formation to the obligations of the buyer and seller and remedies for breach. The 94 state parties to the CISG, Portugal being the most recent, hail from all regions, economic and legal systems, and coverage applies to over 80% of the global trade in goods. As China is one of the world's most active users and promoters of the CISG, the launching of the One Belt, One Road initiative means that CISG will only become more prominent in the Asia-Pacific region and beyond. For those of you interested in learning more about UNCITRAL dispute resolution and other instruments like the CISG, I invite you to join our upcoming virtual events throughout the Asia-Pacific region, including our flagship technical assistance and capacity building activities with the Korean Ministry of Justice and Hong Kong SAR Department of Justice this fall. For our academic colleagues in the audience, UNCITRAL RCAP invites you to co-host an event under the UNCITRAL Asia Pacific Day flagship series. This is an annual event that RCAP co-hosts with institutions of higher learning in the last quarter of every year on a wide range of UNCITRAL thematic issues, such as arbitration, mediation, sale of goods, e-commerce, and many others, with a format ranging from in-class lectures to multi-day regional academic conferences. Finally, UNCITRAL RCAP invites those of you interested in learning more about UNCITRAL or co-hosting an activity with RCAP to reach out anytime via email and to subscribe to our mailing list via the QR code there on your screen. Thank you again for giving me the honor of delivering these co-opening remarks, and I wish the webinar every success.
Thank you, madam, for your insight. Now I would introduce our CEO, Mr. Muhammad Rumee Ali, and request him to kindly deliver his welcome speech. Mr. Muhammad Rumee Ali is the Chief Executive Officer of Bangladesh International Arbitration Center since October 2015. He started his career with ANZ Greenless Bank in Bangladesh in 1975, completing Masters in Economics from the English Bank. Mr. Ali was Chairman of BRAC Bank and CEO of Standard Chartered Bank Bangladesh. Currently, he is also the Chairman of AB Bank Limited. Sir.
Chairman of BIAC Board, Mr. Mahbubur Rahman, Regional Head of UNCITRAL, Ms. Athita, Komindr, panel of speakers and the moderator and distinguished audience. Good morning and Assalamu alaikum. I consider it a privilege to speak at today's webinar, particularly because this is the first time BIAC has jointly hosted a webinar with UNCITRAL Regional Center for Asia Pacific. And we are truly delighted by the presence of a panel of experts, discussants, and a moderator of distinction to take us through this proceedings. Let me extend a very warm welcome to you all, ladies and gentlemen, on behalf of BIAC. Bangladesh has a very good reason for felicitations because this year we celebrate the conjunction of three very important events. 2021 is the 50th year of our independence, the 100th birth anniversary of Bangabandhu Sheikh Mujibur Rahman, the founder of Bangladesh, and the country also celebrates its official graduation from least developed country to a developing nation. The topic of today's webinar is timely and very important one for Bangladesh's future as one of the fastest growing economies of the world. Of late, one of the global indexes which has become a measure of great interest is World Bank's ease of doing business. As countries vie for investor dollars, the thing that tips a decision in favor of one country is the one that reflects the relative investor friendliness of that economy. As a region which is a major recipient of FDI, it takes on more importance. This criticality is not lost on policymakers. A robust dispute resolution ecosystem is a prerequisite to achieve desirable levels of governance in commercial transactions. The apparent low level of compliance in this area has negatively impacted Bangladesh's performance in enforcement of contracts. There are many factors that affect this weak showing, and some of them are well known to all of us, like the backlog, the delays that incur, and of course, the cost issue. I'd like to compare the state of Bangladesh performance on enforcement of contracts to that of a patient diagnosed with chronic obstructive pulmonary disease with multiple obstructions in the blood vessels. While stenting will give some temporary relief, but what the patient needs is coronary artery bypass surgery. In my opinion, this bypass surgery can be achieved by grafting an effective institutional ADR. I believe alternative dispute resolution will assist in achieving adequate flow of blood to the heart of our judicial system. Indeed, this is a proven strategy and is an international best practice. I repeat, we need institutional ADR as opposed to ad hoc ADR. And to ensure transparency, accountability, and governance, just like the judiciary too, we need this whole ADR to be delivered through an institutional framework. And that is why I'm saying time and again, we need institutional ADR to make this whole thing sustainable. So what do we need to do as a country to ensure that the UNCITRAL instruments are effectively used to create a level of ease that helps businesses to grow and flourish in a sustainable way? What changes are required in our ADR laws and processes, and so on? I'm no expert, so I leave this to the panel of experts to talk about it. And for that, we are joined today by a very powerful deck of speakers, all experts in their area. I thank them all for being here. I also thank the moderator. My very special thanks to the regional head of UNCITRAL, Ms. Athita Komindr, whose very, very great speech she just gave has a lot of indicators for our way forward. And I hope policymakers, whoever is listening, has taken note. We certainly have, I have. So I will request her to leave her slides so that we can look at it and do some future programs based on that, and also look at the training programs that you offer. I'd also like to thank Mr. Mahbubur Rahman, who, our chairman, whose relentless support has always been BIAC's main source of inspiration. And finally, I certainly thank all the audience who's here. With these words, and with a very deserved thanks to our BIAC and UNCITRAL teams who were responsible for putting up this event, I invite you all to the webinar. Thank you very much. Khuda Hafiz. Akmal, do you take over now to pass it on to the moderator?
Thank you, sir, for your contribution. I would now like to hand over to the distinguished moderator of today's session, who is Barrister Rashna Imam, an Oxford scholar. She is an advocate of the Supreme Court of Bangladesh and the managing partner of Akhtar, Imam and Associates in law firm. Has been ranked as a leading lawyer in international directories and her main relations in corporate advisory violations, domestic rules, the IATA rules, UNCITRAL rules, Athita, FOSFA, and the Arbitration Act in handling litigation arising out of arbitration proceedings before the Supreme Court, including applications for interim relief, enforcement of arbitral awards, application for setting aside arbitral awards, and application for appointment of arbitrators. The floor is yours, Madam Rashna Imam.
Thank you very much, Mr. Azad, for the very kind introduction. Honorable Chairman BIAC, Mr. Mahbubur Rahman, Head of UNCITRAL RCAP, Ms. Athita Komindr, CEO of BIAC, Mr. Mohammed Rumee Ali, esteemed panelists, viewers and participants, a very good morning or afternoon, as the case may be, to all of you. The significance of our topic today needs no elaboration. Bangladesh is ranked 168 among 190 economies in the World Bank's latest. Am I audible? The internet connection is a little unstable at my end.
We can hear you, ma'am.
Thank you. Thank you.
Yes, yes, you are audible.
Going back to our ranking, this ranking 168 is categorized as below average. And one of the indicators based on which Bangladesh is ranked is in contracts is concerned. Our ranking is 189, which is second last. The World Bank report shows that on an average, the enforcement of a contract in Bangladesh, a commercial contract through a local first instance court, takes around 1,442 days, roughly about 4 years. So this is almost 3 times more than 590 days, which is the average for OECD high-income economies. And the costs associated with enforcing these commercial contracts are also very highly prohibitive, which is around 66.8% of the value of the claim itself. So question arises, what do we need to do about that? And one of the things that we need to do is our topic of discussion today, which is to promote the use of alternative dispute resolution, wider use of alternative dispute resolution mechanisms like arbitration and mediation, amongst others, and of course, address the inadequacies in the legal frameworks that we have in place. For example, the Arbitration Act 2001. This can effectively be done by using the UNCITRAL EDR instruments, which Ms. Athita Komindr was speaking of. And of course, the revised UN model law can be used to address the inadequacies and bring about reforms in the Arbitration Act 2001. So without further ado, ladies and gentlemen, I'd like to turn to our esteemed panelists today. There is a lot of ground to cover and very limited time. As such, I would humbly request our panelists to keep their inputs to 6 minutes each. Apologies in advance if I have to cut anyone short. With that, I turn to our first panelist today, Mr. Kazi Arifuzzaman. He is the Joint Secretary, Legislative and Parliamentary Affairs Division of the Ministry of Law, Justice and Parliamentary Affairs, Government of Bangladesh. He has been with the ministry for more than 2 decades. Prior to this, he practiced as an advocate of the Supreme Court of Bangladesh. Mr. Arifuzzaman, if you may kindly share your insights on how use and adoption of these UNCITRAL ADR instruments may affect ease of doing business in Bangladesh and may ensure speedy resolution of commercial disputes. If you may.
Honorable Chair, distinguished participants, speakers, panelists, ladies and gentlemen, Assalamu alaikum, and a very good afternoon. It is indeed a great pleasure and privilege for me to be here with all of you at the webinar titled Regional Perspective of UNCITRAL ADR Instrument on Ease of Doing Business in Asia and Pacific, which is jointly organized by UNCITRAL Regional Center for Asia and Pacific and Bangladesh International Arbitration Center. As we are aware of the fact that UNCITRAL ADR instruments such as Convention on Recognition and Enforcement of Foreign Arbitral Award, the New York Convention 1958, the UN Convention on International Settlement Agreement resulting from mediation, the Singapore Convention on Mediation 2018, and accompanying UNCITRAL model laws, rules, and explanatory text offer legislative framework to facilitate commercial dispute resolution mechanism in cross-border. By this time, Bangladesh has climbed up different steps by reforming different indicators towards ease of doing business. Improvement have been made in the field of starting business, getting electricity, getting credit. More emphasis are given to deal with construction permits, registering property, paying taxes, trading cross borders, enforcing contract, resolving insolvency, protecting investors, etc. Traditional court system is time consuming and cumbersome to settle the commercial dispute. So there is consistent sound legal and regulatory framework in place in Bangladesh relating to ADR. Well-established case management system, court automation, computerization are needed to efficient and effective legal and judicial system. Bangladesh is gradually moving towards that system. Government has undertaken different projects to that end. There are special commercial courts, special claims courts, settlement conference, and pre-trial conference to narrow down contentious legal issues may be made possible within our legal and judicial system. Tracking of status of cases online is now made possible in higher judiciary in Bangladesh. Daily cause list of Supreme Court may be found electronically. Lawyers can also plead a case by virtue of Virtual Courts Act 2020 virtually. One Step Services Act 2018 provides an opportunity towards ease of doing business. The present traditional court-based dispute resolution mechanism may not be considered that much congenial in terms of settling commercial dispute. Rather, focus has been given to ADR system, particularly in the form of arbitration, negotiation, mediation, and conciliation. Our Arbitration Act 2001 is a modern one based on UNCITRAL model law on arbitration, which is also working effectively. In commercial arbitration, the parties agree to submit their dispute to an independent arbitration or arbitral tribunal, which issues a final binding award. In mediation or conciliation process, the parties ask a third party to assist them in reaching an amicable settlement of dispute. It is proved that ADR system is more effective than that of traditional adversarial court system, which is not cost-effective and speedier. Side by side, ADR mechanism may bring efficiency in deciding disputes, removing backlog of cases, reducing high cost and delay. To my estimation, as a reasonable person, access to justice is more ensured by ADR than that of traditional court system. That's why popularity of ADR is increasing day by day, particularly settling commercial dispute, which is confidential in business relationship. Lawyers community should come forward to encourage litigants to settle the dispute through ADR because it saves business time and money. In complex business dealings, a special ADR program may be introduced, engaging technical experts in the related fields. I would like to further emphasize the fact that in ease of doing business, a good legal and regulatory framework is available and which is also needed for that end. And to promote a sustainable and inclusive business environment, Bangladesh Investment Development Authority, BIDA, has undertaken numerous reforms to ensure one-stop services to investors, facilitating business environments to the entrepreneurs. Efforts are also made by Bangladesh in various indicators in the field of ease of doing business shown by the World Bank, World Economic Forum, and others. All these efforts are being made by Bangladesh to achieve sustainable development goals. Noted that Bangladesh is a party to the New York Convention on Recognition and Enforcement of Foreign Arbitral Award and a fruitful, significant, effective Arbitration Act 2001 based on UNCITRAL model law is enacted in Bangladesh, which is working well. Section 45 of the Prevailing Arbitration Act in Bangladesh provides for recognition and enforcement of foreign arbitral award on an application made by a party following the execution process of a decree under the Code of Civil Procedure to execute a foreign arbitral award. An authenticated exact certified copy of the arbitral award obtained from that foreign jurisdiction, original and authenticated certified copy of the arbitration contract, such as other proof as determined, requires to be filed. At the time of filing an application for execution of a foreign arbitral award, authenticated translated copy channeled through the diplomatic mission of that very country requires to be obtained so as to determine its accuracy. This is the high time for Bangladesh to think about how to become a party to Singapore Convention 2018 on mediation. Executive and legislative framework to that end may be prepared. Further noted that Arbitration Act 2001 may be revisited in consultation with the stakeholders so as to determine its sufficiency or insufficiency for its smooth functioning. Finally, I would like to appreciate Bangladesh International Arbitration Center, BIAC, which since its inception is advocating sincerely, demonstrating various indicators, facilitating ease of doing business, and ADR is one of them. Evidences show that ADR system has become successful in family courts and labor courts. Now it is the high time to address the issue in the commercial dispute resolution mechanism through ADR in the time-bound manner, and which is a long overdue. Thereby the dream of the father of the nation, Bangabandhu Sheikh Mujibur Rahman, to build up a golden and prosperous Bengal may be materialized, and which is the ultimate destination of Her Excellency Honorable Prime Minister Sheikh Hasina. With these few words, I would like to conclude. Thank you so much for patience hearing. Thank you all.
Thank you very much, Mr. Arifuzzaman. Thank you for sharing the progress that Bangladesh has made till date to promoting the use of ADR, and that we do have a long way to go. Thank you also for pointing out that it is time that the Arbitration Act should be revisited and necessary reforms made to the Act to improve the effectiveness of arbitration for users in Bangladesh. And of course, for pointing out that legal practitioners can play a very important role in encouraging clients to opt for ADR mechanisms to resolve their commercial disputes and dissuade them from litigation, given the colossal backlog in the courts of Bangladesh. Thank you very much. I shall now turn to our second panelist today, Mr. Changwan Han. He is the Director of International Dispute Resolution International Dispute Settlement Division of the Ministry of Justice, Republic of Korea. Before being appointed to the current position, he was the Director of International Legal Affairs Division. Prior to joining the ministry, he served as Judge Advocate for South Korean Army and then became an associate and later partner at a large Korean law firm by Kim and Lee. Thank you, Mr. Han, for joining us today. And if you may kindly share how your insights on how the use and adoption of UNCITRAL ADR instruments may affect ease of doing business in Asia and the Pacific. And we would be grateful if you could give us some examples of countries within the Asia Pacific region that have benefited from these UNCITRAL ADR instruments. Thank you.
Thank you, Nijima, for the kind introduction. And hello, everyone. And I wanted to thank BIAC and UNCITRAL RCAP for having me today. I'm so glad to be here today with all of you. As I have only 6 minutes, I think, for my presentation, I will get to the point right away. Okay, now let me share my screen now. Can you see the screen?
Yes, sir.
Okay, thank you. As previous distinguished speakers eloquently pointed out, dealing with dispute can often be expensive and time-consuming, and due to the rapid and continuous change characterized by globalization, internationalization, digitalization, and specialization, it becomes increasingly important to resolve dispute as expeditiously and efficiently as possible. Therefore, effective and stable dispute resolution mechanisms can play a hugely important role in promoting sustained economic growth and attracting foreign direct investment. In this regard, today I would like to talk a little bit about Korea's experience. After the financial crisis in 1997, Korea wanted to develop the dispute resolution processes in order to establish cost-effective and time-efficient alternatives to the traditional court system. Above all, it is important to prevent a dispute involving foreign investors in the first place. In order to prevent dispute and resolve grievances of foreign capital invested companies operating in Korea, the Foreign Investment Ombudsman system was established in 1999. Foreign Investment Ombudsman system and his grievance resolution body collect and analyze information concerning the problems foreign firms experience and request cooperation from various administrative agencies and provide them with recommendation and the implementation thereof. And they also propose new policies aimed at improving the foreign investment promotion system and carry out other necessary tasks to assist foreign invested companies with resolving their grievances. Any foreign investor and companies registered as foreign capital invested companies in Korea are eligible to use Foreign Investment Ombudsman system. The entire grievance resolution services, including consultation and assistance, is provided at no cost. And you can see here on the screen the areas of grievance consulting. Okay, now let's move on to the next topic. Okay, as you may know, there are various forms of alternative dispute resolution mechanisms in Korea. Among them, the most frequently used method is arbitration, both for domestic and international dispute. The bedrock of arbitration in Korea is the Korean Arbitration Act, which was first promulgated in 1966. In 1999, Korea revised Korean Arbitration Act to substantially adopt the UNCITRAL model law. Actually, Korea became the first country in Asia to adopt the 1985 UNCITRAL model law on international commercial arbitration. As you may recall, the UNCITRAL model law put forward legislative provisions as a means to harmonize national laws worldwide. In 2016, Korea also again revised the Arbitration Act to implement the international best practice standards incorporated under the 2006 revision of the UNCITRAL model law. Also, the KCA-B International Arbitration Rule underwent a significant change in 2016, adopting many of the most up-to-date international practices. Most notably, the arbitration rules introduced an emergency arbitration procedure and procedures for multi-party arbitration. Right. In 2017, Korean Arbitration Industry Promotion Act also came into effect. This act also includes provision to expand dispute resolution facilities, to cultivate experts and professionals in the area of arbitration, and to support research and development in the arbitration field. Also, in order to establish reliable international arbitration practices in Korea, KCA-B International was launched in 2018. Since then, KCA-B has been able to enhance its general and institutional reputation, the level of professionalism of the staff, the predictability in case management practice, and quality and expertise and diversity in its arbitrator pool. KCA-B International has contributed to the growth of the arbitration industry in Korea. As you can see here on the screen, the number of cases has been increasing since the launch of KCA-B International, which is testament to the thriving arbitration practice in Korea and the region. At the beginning of today's event, I saw the excellent video about BIAC, and I hope that BIAC will continue to be successful in the future as well. Okay. We also have court supervised conciliation and mediation. Court unacted conciliation is a procedure to be commented by a petition of a party or rebuttal by a judge to whom the case is assigned. Conciliation and mediation in Korea have been administered by court or administrative agencies in accordance with relevant act. Korea was also one of the countries which signed the Singapore Mediation Convention in 2019. Because we think the Singapore Mediation Convention can play a significant part in the facilitation of international commerce and provide greater business assurance. We are now putting in an effort in the adoption and implementation of the convention into domestic system. I think it will take us like at least a year. Okay, now let's move on to next slide. Okay, as you can see here on the slide, we have various specialized resolution processes as well. Let me briefly point out the e-commerce mediation committee, because electronic commerce is increasingly becoming important in Korea and around the world as well. This committee was established to mediate all disputes in electronic commerce. The mediation can be conducted online, and any application for and decision made in the mediation process may respectively be filed and rendered electronically. All right. Okay, as mentioned earlier, the alternative dispute resolution system, including arbitration in Korea, is very important. They provide us speed and convenience and allowed for comparatively low cost and consensual resolution dispute. As Mr. Komindr already mentioned earlier, and you can see here on the screen, according to the World Bank Doing Business Report 2020, South Korea ranked 5th among 190 economies in ease of doing business, and especially ranked 2nd in enforcing contracts and 11th in resolving insolvency. This may show that having an effective legal framework in place can improve business environment. In this regard, I must say that UNCITRAL instrument will continue to play an important role in the improvement of business environment as well. My final point is that, as I said earlier, Korea is now trying to adopt and implement the Singapore Mediation Convention, and it would help Korea improve its dispute resolution mechanism further. Okay, I think now my time is up, and I think that's it for now, and this wraps up my observation, and I'll be happy to answer to any question, if any, during the Q&A session later. Thank you all.
Thank you very much, Mr. Han, for sharing your valuable insights, in particular the Korean arbitration experience till date and how Korea has very proactively amended its arbitration acts and rules to keep pace with the changing standards of arbitration globally, and for sharing with us the mediation experience so far as Korea is concerned, that they have signed the Singapore Convention and are now in the process of incorporating the various provisions into their domestic legal frameworks and bringing about amendments to the infrastructures in place to promote mediation for resolution of commercial disputes. Thank you very much once again. If I may now turn to our third panelist today, Ms. Humaira Azam. She is the Managing Director and CEO of Trust Bank Limited with more than 3 decades of experience in the banking industry. She is the first ever Bangladeshi woman to be recognized as one of 300 influential women in Islamic business and finance in the world by UK-based financial intelligence house Cambridge IFA in their Woman Eye Report 2020. Thank you very much, Ms. Azam, for joining us today. If you may kindly share with us how the use and adoption of UNCITRAL ADR instruments may improve the resolution of disputes between banks, non-bank financial institutions, and consumers in an amicable, balanced, speedy, and cost-effective manner. And of course, the effectiveness of the existing legal frameworks that we have, like the Money Loan Court Act, has provisions and mediations. To what extent do you think these are implemented and used, and how effective they are? Thank you very much, and apologies for the slightly long question.
Good afternoon and Assalamu alaikum, everyone. Am I clear? Okay. I would first like to say thank you to BIAC for this opportunity for me to be here, and would like to address Head of UNCITRAL and Chief Executive BIAC and all the other valued participants, and also whoever is being here in this webinar. Actually, Bangladesh has experienced a major growth, we know that, and also the trade pattern worldwide has changed, because everything has now, even at the initial stage, we were looking at LCs and standby LCs and all those, and later on, all the cost of doing business also applies there, and the method has changed over the years, and contract has become a major part of the business. So all the, even garments or any other export business, or we are seeing actually contracts, and these are now contract based. So once the contracts are in place, also we need to take in account that Islamic banking that we talk about, that it is Garar we talk about, and those are also financial contracts that we work with. So it's a question of what sort of instruments we are dealing with, and whether our contracts on the first place has got a space for ADR, because that would be the first place we need to address something, because any instrument that we are looking at, our flaw would remain there if we have not incorporated ADR over there. So once it is there, it makes things much easier to move on and move it smoothly. And we have heard all the data and everything. If we look at the amount of contract as 15% of the total, we were talking about that, what is the contract that is being taken care of. So if you look at it, it's 555,000, which is now available as disputed. And also what we can see that Orthorin Adalat does have a space for in the 22nd chapter, in the 5th chapter, and from section 22 to 25th, there are provisions for different instruments, and they are talking about ADR, but saying that we have not seen our position improve. Because if you look at the data, even World Bank data reveals that we are absolutely in the bottom. So what is happening here? And if you want to improve the financial scenario of this country, you have to actually address this situation. And an insolvency position cannot be improved without addressing, obviously, this particular place where we will need ADR. And rightly, as mentioned by, I think, the Chief Executive of BIAC, that we'll need institutional ADR. It cannot be ad hoc ADR. So I think when we are looking at, and also at the beginning, we were looking at that we'll need, there is a huge correlation in enforcing contracts, and we have to make sure that we have the necessary resolutions in place. So when we are looking at the resolutions, then definitely UN Convention on Contracts for International Sale Contract Resolution must come in place. So we need to also look at what are the bilateral and multilateral instruments available, and what are the conventions, because once we adopt, because we are doing trade with every single country. So if we are able to go with that, because there is New York Convention and there is Singapore Convention, and we need to actually be in it. So once when we are speaking the same language, because we have also seen that international trade, whenever you are looking across the border, you look at URDG, UCP, and you accept it. It is exactly like that, and you will have to go for ADR in that manner. And once you adopt all the conventions, it will become much more easier. And as I have said, that even within the parameter of different cases, I think even with the court cases and everything, we have to have the option of having ADR in place. And because obviously when you are in an informal atmosphere, you have the opportunity to, is my time out or something, or am I, hello?
Hello.
Yeah.
You may continue for a minute. Apologies for the rush.
My time is out. Okay, fine, not a problem. But what I can say is when you are looking at this situation, I do believe that for Bangladesh, I think it's of utmost importance when it comes to financial improvement, because actually that allows you the country rating and how everyone is looking at you. So I think this will become a critical factor for success going forward if we can adopt this and we can actually put it in our every place. And even in whenever we are looking at different resolution sharing in court systems and everywhere, I think it works. Anyway, thank you very much. Thanks a lot.
Thank you very much, Ms. Azam, for sharing your valuable insights with us. Just to follow up on some of the points Ms. Azam made. One is the importance to insert ADR clauses in contracts in the first place. Of course, we know it's there in the Arbitration Act that even if an arbitration clause is not there in a contract, the parties may agree to opt for ADR or arbitration at a later stage when a dispute arises, but it adds a lot of certainty if it is already there in the contract. Another point that Ms. Azam made was how it is absolutely critical that we need to institutionalize ADR in Bangladesh. Nothing short of institutionalization will actually promote the use of ADR mechanisms. And of course, we need to adopt and use these UNCITRAL ADR instruments like the New York Convention, the Singapore Convention, and not just be a signatory to it, but incorporate these provisions into our laws and actually implement these laws. And of course, how critical all of this will be to the economic development of Bangladesh. Thank you very much, Ms. Azam, again for the very valuable points that you've made. If I may now kindly move to our next guest today, Ms. Nam Yong Yang. She's a legal expert of the UNCITRAL Regional Center for Asia and the Pacific on secondment from the Ministry of Justice, Republic of Korea. She worked in several government institutions and agencies on public international law. Prior to joining UNCITRAL RCAP, she worked as legal officer in the International Legal Affairs Division, Ministry of Justice, Republic of Korea. She also worked for the Korea Legislation Research Institute, mainly participating in adopting various international norms into the Korean legal system. So very relevant for our discussion. Welcome, Ms. Hyung, to our webinar today. If you'd kindly share how UNCITRAL ADR instruments may impact resolution of commercial disputes within the Asia-Pacific region, and of course, if you could give us some concrete examples, that would be very useful for our viewers and participants. Thank you.
Thank you very much for your kind introduction. And since I have only 6 minutes, I right away start with my presentation. And can you see my slide well? Yes. So, as introduced, I'm Incheon, a legal expert at UNCITRAL RCAP. I'm very pleased to be here to introduce UNCITRAL's arbitration instrument in this webinar co-organized by UNCITRAL RCAP and BIAC. Here is a list of the instruments that UNCITRAL has developed so far in the field of dispute resolution. A harmonized and enabling environment for dispute resolution has been part of UNCITRAL's work program since its inception in 1966. Let me start with the New York Convention. In the area of arbitration, UNCITRAL is best known for promoting the adoption and the uniform application of the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Award, known as the New York Convention, a multilateral treaty adopted in 1958 before UNCITRAL was established to address the recognition and enforcement of foreign arbitral award and agreement to arbitrate. The convention ensures that foreign arbitral awards are not discriminated against in the jurisdiction of the contracting state and are recognized and generally capable of enforcement in those jurisdictions in the same way as domestic award. The convention also requires the court of the contracting state to give full effect to arbitration agreement by requiring state court to deny the parties access to court if the parties have agreed to solve their dispute through arbitration. It has significantly contributed to create a system of dispute resolution based on good governance and the rule of law. As you can see the map in the slide, with near universal participation by 168 states, the latest being Belize, the New York Convention provides common legislative standards for the recognition of arbitration agreement and court recognition and enforcement of foreign and non-domestic arbitral award, subject to only specific limited exceptions, and thus facilitates the resolution of dispute in all corners. Let me move to the UNCITRAL Model Law on International Commercial Arbitration, adopted by the United Nations General Assembly in 1985 and amended in 2006, which supplements the regime created by the New York Convention. The model law establishes a unified, fair, and efficient legal framework reflecting worldwide consensus on the principles and important issues of international arbitration practice while providing flexibility for enacting jurisdictions. It provides guidance to states on how to reform and modernize their law on arbitral procedures so as to take into account the particular features and needs of international commercial arbitration. It covers all stages of the arbitral process and conforms to current practice in international trade and modern means of contracting with regard to the form of arbitration agreement and the granting of interim measures. As of April 2021, legislation based on the model law has been adopted in 85 states in a total of 118 jurisdictions. Enacting Asia-Pacific states include Australia, China, Fiji, India, Japan, New Zealand, Republic of Korea, Singapore, and many others. Bangladesh is also one of the enacting states in the region. Another major UNCITRAL text is the arbitration rules that provide a comprehensive set of procedural rules upon which parties may agree for the conduct of arbitral proceedings. The rules were adopted in 1976 and revised in 2010. They were designed as a neutral and universal set of rules covering all major procedural issues in arbitration and have been widely used globally in both institutional arbitrations and ad hoc arbitrations. The parties have the flexibility to modify any of its provisions in the rules to suit their needs. The rules were intended to be acceptable in all political and legal systems and applicable for both contract-based and treaty-based arbitration. In addition, UNCITRAL has carried out work to enhance transparency and public accessibility to investor-state arbitration, which is a key aspect in those proceedings. We also have the UNCITRAL Notes on Organized Arbitral Proceedings, which provides an annotated list of matters on which an arbitral tribunal may wish to formulate decisions during the course of arbitral proceedings. The text may be used in both ad hoc and institutional arbitrations. The notes initially adopted in 1996 and updated in 2016. It emphasizes the flexibility of arbitration, party autonomy, and discretion of the tribunal to make certain decisions and conduct proceedings as it considers appropriate. Before wrapping up my presentation, I would like to mention the cloud and the digest of it. In accordance with its mandate, to further the progressive harmonization and modernization of the law of the international trade, UNCITRAL has established a reporting system for case law on UNCITRAL Text Cloud. It was established in order to assist judges, arbitrators, and lawyers by making available decisions of court and arbitral tribunals interpreting UNCITRAL text, and in so doing to further the uniform interpretation and application of those texts. In light of the large number of the cases collected in cloud on the model law, the Commission requested to make a tool specifically designed to present selected information on the interpretation of the model law in a clear, concise, and objective manner. This request originated to digest of case law on the model law. The digest was launched in 2012 and is usefully organized according to model law chapters and articles. It provides a summary of a case law for each article, highlighting common views and reporting any divergent approach, and included 725 cases from 37 states all over the world. We also publish more recent cases on the model law in the UNCITRAL Cloud Digital Database, also accessible on the UNCITRAL website in all 6 UN languages.
Apologies,
pardon me?
But I believe we have come to the end of your presentation.
Yeah. So this is the end of my presentation. Thank you very much for your attention.
Thank you very much. Thank you very much for a very informative presentation, for taking us model law on international commercial arbitration and how it has been subsequently amended, which is a particularly useful information for Bangladesh because our Arbitration Act is 20 years old. And it is about time that we keep pace with changing standards of arbitration globally and adopt the revisions made to the original UN model law based on which our Arbitration Act was drafted. And of course, for taking us through the other instruments like the arbitration rules, the rules on transparency for investor-state arbitration, and a few others. and that and emphasizing how these are all designed for universal usage, and that all countries, doesn't matter which level of economic development, stands to benefit by adopting and using these ADR instruments. Thank you once again. We'd now like to quickly move on to our next panelist today, Dr. Jamila A. Chaudhry. Dr. Chaudhry, if you'd kindly turn the video on and join us. She is a professor at the Department of Law, University of Dhaka. She holds a PhD in dispute resolution from the School of Law, University of Sydney, Australia. She earned a gold medal for securing first-class first position in LLB Honours, a UNESCO Fellowship, Australia Day Award by the National Council of Women of New South Wales, Australia, and the Bangladesh University Grants Commission Award twice for her tenacity and creative abilities in academic and research work. She has authored many international publications on ADR and women's rights. Dr. Chaudhry, if you may kindly share your insight on how best to go about promoting wider use of ADR mechanisms in Bangladesh, and in particular, business leaders as well as professionals have long called for the reform of the Arbitration Act 2001. So if you could give us your view on how the Arbitration Act 2001 be reformed or amended, that would be, we would be grateful. Thank you, Dr. Chaudhry, if you may.
Yeah, thank you so much, dear moderator. Whether I'm audible to you?
Yes, yes, you
yes,
are.
Whether I'm visible to you too. Yeah, I'm there. Okay,
yes,
thank you.
Audible and visible.
Okay, thank you. So, distinguished guests, my esteemed colleagues, participants of this webinar, a very good morning to you all. Since we are under very much time constraint for discussing this vast topic, I'd like to introduce the problem that I perceive in establishing a regional standard and a common practice of ADR. Then I shall indicate a way out, a very brief way out of how we may progress further to attain this goal. As we all know, UNCITRAL introduced its model to fulfill deficiency in national laws and harmonize national laws while dealing with international commercial arbitration awards. Afterwards, many countries have adapted the law in their national arbitration laws with necessary modifications. Here it is pertinent to mention that the model law was based on the postmodern concept. Here I'm repeating the word postmodern concept because according to the postmodern concept explored by Foucault, concept of right or wrong is contextual. Law is not an exception in this regard. Hence, the model law was developed as a guideline for enacting national laws, not something rigid. The national government can amend it and just complying with its competent courts, also have the jurisdiction to interpret their arbitration laws following their own legal culture and trade practice. For this instance, Section 520, in light of Section Arbitration Act 2009, I would refer Section 529, 30, 21, 42, 44, 45 of the Arbitration Act 2001 of Bangladesh. Bangladesh were developed following Article 3, 23, 24, 17, 34, 35, 36 of UNCITRAL model law on international commercial arbitration. However, there are some sections which are not very similar with UNCITRAL model. If I just compare with Arbitration Act, that means, for example, Section 10 and 11 of Bangladesh. Okay, that discuss about number of arbitrators differs from what is the mentioned in the model law. It is natural that every law will accept such changes. However, problems arise when a number of nations start with the same model law and then some countries remain dynamic and make necessary changes. For example, Korea, since the Koreans representatives are here. I'm just mentioning its name. There are some countries too, while other remains very static. Therefore, countries can easily diverge from each other. Before going to indicate the way out from the diversity and establish harmony, I'd like to highlight the steps that countries may follow to develop a legal system. This could be, number one, enactment of laws. Number two, adaptation of new law with the legal structure. Number three, integration of new law with the practitioners and users. And last but not least, change the latent behavior pattern of the society to accept that changes. Perhaps I'm taking much time, a bit more. For example, when a new law is enacted, one form of its adaptation comes through judicial interpretation. Judicial activism or interpretation may fulfill the gaps and inconsistencies in the law. Such adaptation could be a lengthy process. For instance, when India formed its Arbitration and Conciliation Act 1996, following the ancestral model law, new confusion arose about the seat. I'm again repeating the seat, which is now a very debating topic in arbitration arena, seat of international commercial arbitration after its judgment from the Supreme Court of India in Bhatia International versus Bulk Trading in 2002. However, the confusion regarding party autonomy in choosing their seat continues until Bharat Aluminium Company, that means in shortly Balco case in 2012. This issue was finally settled by the Indian Supreme Court in the BSG Suma case in 2019. However, such a long process of adaptation is not practical in the modern business world. People need more certainty with less time. The good news is that in its last amendment, that means Indian last amendment of the Arbitration and Conciliation Amendment Act 2019, Section 43A and Section 43A introduced an separate arbitration council of India. The council is assigned for different adaptation activities, etc. It's not my time to just separately mention all these activities what are dealt with by the arbitration council. That I'm skipping that part. We also find the similar initiatives in Korea, as I mentioned earlier, under the Korean Commercial Arbitration Board, that means KCA-B. In 2019, Korea enacted a new law, as one of my esteemed colleagues has already mentioned this one, to promote arbitration culture in their country. It will encourage integration and also bring changes in the latest and modern pattern. The bottom line is that while UNCITRAL started its journey with the development of model laws, and many countries have already adopted those models in their national laws, now it's high time to take some new challenges. UNCITRAL may promote advisory councils in different nations and keep close contact with those epic bodies. It will standardize national laws, at the same time make regional cooperation easier. An organization like BIAC and different chamber of commerce may organize and sponsor national events in this regard, which BIAC is doing spontaneously day by day. If we see the BIAC activities for the last 2 or 3 years for promoting mediation and arbitration in Bangladesh. The government may, apart from BIAC, the government may lead this process by organizing RegNeg, that means one forms of hybrid idea, that means regulatory negotiation. Shortly, we just term it as RegNeg, and integrate academicians and practitioners in these processes.
Thank you very much.
Yeah, thank you so much for organizing this time. And thank you, dear moderator, for giving me the floor to say
such a shot like this. We would
yeah,
really
thank you.
hear from you. Hopefully we'll get a chance in the question answer segment that is to follow.
Yeah.
Dr. Chaudhary, one of the key takeaways from what Dr. Chaudhary said was getting a law right, a legal framework right, is really a trial and error process. So we have to, as a country, as a nation, we have to choose to be dynamic as opposed to static, and bring about changes to our Arbitration Act that keep up with the changing standards of arbitration globally. Again, to repeat, our Arbitration Act is based on the UNCITRAL Model Law of 1985. Since then, the model law has undergone several amendments, but our Arbitration Act is yet to keep up with those amendments. So that is one of the key takeaways from what Dr. Chaudhary said. Another one was a very useful comparison of the Indian experience, the Korean experience, with the Bangladeshi experience. Thank you so much, Dr. Chaudhary, for that. If I may now turn to our last speaker today, Ms. Jenny Hui. She is a senior government counsel at the Department of Justice of the Government of Hong Kong, Special Administrative Region. She is currently seconded to the UNCITRAL Regional Center for Asia and the Pacific as legal expert. Prior to this, she was serving in the Constitutional and Policy Affairs Division and was admitted as solicitor in Hong Kong. Ms. Hui, if you would kindly tell us a little bit more about how, in your view, the use and adoption of these UNCITRAL ADR instruments may affect the ease of doing business in the Asia-Pacific region in general. And of course, one question that we would be grateful if you could address is whether these are suitable for countries at different levels of economic development. Thank you.
Thank you very much. I see that my time is running very short, so allow me to be extremely brief. Yes. So UNCITRAL began its work in mediation as early as in 1980s with the understanding that there's a need for unification of mediation regulations. And for a long time, the use of mediation in cross-border disputes was challenged for a lack of an efficient and harmonized framework for cross-border enforcement, in contrast to arbitration, which benefits from the New York Convention. In response to this, in 2018, UNCITRAL developed two instruments in parallel in an effort to further promote mediation as an effective dispute resolution method, a convention providing a uniform and efficient framework for the enforcement of international settlement agreements resulting from mediation, and an update to the model law of 2002. Such a multilateral lawmaking process provides states with the flexibility to adopt either the convention or the model law as a standalone text, or both as complementary instruments of a comprehensive legal framework on mediation. So referring to the moderator's question just now, as you can see, currently there are 53 signatories of the convention, representing over half of the global population, and include the world's largest economies, namely US, China, and three of the largest economies in Asia, China again, India, and South Korea, all of which are Bangladesh close trading partners. And not only these countries have adopted, other countries with diverse legal traditions and different levels of developments have also adopted, such as Afghanistan, 5 ASEAN member states, a number of states in Africa and South America. And in terms of South Asia, as you can see, currently Afghanistan, India, Maldives, and Sri Lanka are signatories. Bangladesh has yet to join, and UNCITRAL very much look forward Bangladesh and states in the region to join the Singapore Convention soon. So some of the benefits of joining the Singapore Convention on Mediation are as follows. It provides an efficient and harmonized legal framework for enforcing international settlement agreements resulting from resulting from mediation. And this in turn enhances the dispute resolution mechanisms of a state by providing international mediation settlement agreements with the same status as international arbitral awards and judgments, the latter two being capable of enforcing through the New York Convention for arbitration or the relevant Hague Conventions or at common law for litigation. The convention provides legal certainty and predictability, which are all conducive to the doing of business, attracting foreign direct investment and cross-border trade, because clear rules give people confidence and minimize transaction costs and time for ascertaining what the foreign legal system is. And having the confidence that a settlement agreement is capable of being enforced in another state party would encourage the use of mediation. Because if a party knows that the end result will not be enforceable, the outcome, no matter how ideal, would be useless to the parties, and the parties will not choose mediation at the first place. And mediation also provides MSMEs with more informal, flexible, and efficient dispute resolution tools to deal with commercial disputes, which are often disproportionate to go to court, given the size of their claims. And joining the convention would support the healthy functioning of these MSMEs. And lastly, as highlighted by the United Nations Secretary General Antonio Guterres in his annual report last year, the convention implements Goal 16 of the Sustainable Development Goals as it enhances access to justice for all by facilitating the use of mediation, which is a simpler and more easily accessible method of dispute resolution in many instances than complex litigation and arbitration to resolve cross-border commercial disputes. And with that, I think we could wrap up here. So thank you very much. Yes.
Thank you very much, Ms. Hui, for the very informative presentation. You've taken us through texts on mediation that UNCITRAL has to offer the world. And you've made a very compelling case for the Singapore Convention being of a very wide and universal usage, and how most of Bangladesh's trading partners are signatories to it. And so it is about time that Bangladesh also adopts and implements the provisions and incorporates it into Bangladeshi law. And of course, you have very concisely taken us through the benefits of adopting UNCITRAL ADR instruments. Just to quickly recap some of the benefits you said, first and foremost, this would provide an efficient and a harmonized legal framework which is conducive to cross-border business. Then this would introduce legal certainty. So far as foreign investors coming into Bangladesh is concerned, legal certainty is one of their top concerns. So this would address that problem squarely. These mechanisms would be cost effective, and it would be conducive to MEAs flourishing and thriving. And of course, all of this would contribute to Sustainable Development Goal. It'll take us one step closer to Sustainable Development Goal 16. Thank you very much. I will now, as much as we would like to have a question answer session, but we are running beyond schedule, so we'll skip that session, and I'll make a humble attempt to summarize the key takeaways from our webinar today. The first key takeaway would be that there is clearly a compelling case for resolution of commercial disputes through alternative dispute resolution mechanisms as opposed to litigation. Two reasons behind this is that enforcement through local first instance court, if we are to take Bangladesh as an example, is extremely time consuming and expensive and adds to the already colossal backlog of cases in our courts. And the other reason would be that the very adversarial nature of litigation is such that this would mean irretrievable breakdown of the business relationship. So this would not be ideal for any business entity. Moving on to our second key takeaway, I believe there's been a consensus from all the Bangladeshi experts on this matter, which is that it is about time that the Arbitration Act 2001 is reformed. And even though this act was based on the UNCITRAL Model Law 1985, that model law has undergone change, and it's about time that we adopt those change and adopt international best practices so that we are keeping up with the changing standards of arbitration globally. Moving on to the third key takeaway, which is it is imperative to institutionalize mediation in Bangladesh. Nothing short of institutionalization would promote mediation as it should be promoted. And of course, as for the acceptability of UNCITRAL ADR instruments, all of our speakers today have time and again pointed out that these instruments have actually been created and negotiated through an international process that involved a variety of stakeholders from different jurisdictions representing different levels of economic background and legal traditions, which makes these institutions very, very user-friendly for any country for that matter, and including the Asia-Pacific region, which is the topic before us today. So these should be adopted in Bangladesh and in the Asia-Pacific region. And last but definitely not the least, if we are to effectively use and adopt these instruments and promote and popularize alternative dispute resolution, this will have a direct impact on the economic development of Bangladesh and any country in the Asia-Pacific region for that matter, because this would mean resolution of commercial disputes would be cost-effective, would be speedy. This would attract foreign investment and create a thriving, enabling environment for local businesses to flourish in. Without taking up any more time, I would now like to wrap up our discussion and invite the Honorable Chairman of the Board of BIAC, Mr. Mahbubur Rahman, to deliver his closing remarks. He is the current and founding Chairman of BIAC, the President of International Chamber of Commerce, Bangladesh. He's the only arbitrator in Bangladesh at the China International Economic and Trade Arbitration Commission. Mr. Rahman is the Chairman and CEO of ETBL Holdings Limited and Chairman of the International Publications Limited, the company that publishes Daily Financial Express. He hosted several international business and economic events in Dhaka, attended by heads of governments, and led many trade and investment delegations to a number of overseas destinations, including business delegations that were entourage of the President and the Prime Minister of Bangladesh. Thank you and welcome, Mr. Mahbubur Rahman, sir. If you would kindly deliver the closing remarks for our webinar today.
Thank you very much. It has been a great pleasure for me to join you this afternoon in Bangladesh and, of course, a little early for Hong Kong and South Korea. And at this point of time, I would like to say thank you very much for organizing this important event with the UNCITRAL. The reason being, as you know, that UNCITRAL is the model law which everyone tries to follow. And you are very right in saying that despite the fact that we have adopted our arbitration act on the basis or taking a cue from the UNCITRAL law, but UNCITRAL went ahead with several amendments subsequently, but it has not been taken care of by the government at the appropriate time. It is high time that we should look into this area to make it more compatible. And as far as the Singapore Mediation Convention is also, as you said, the sum of the regional countries has already joined, Bangladesh yet to join, and I think Bangladesh should look into this so that everyone takes it seriously, that Bangladesh is a total partner in this situation. And arbitration and mediation in Bangladesh for all new investors would be more encouraging for them to come in. I have some prepared text for you to given by my office. And let me say the Assalamu alaikum and good afternoon to each one of you. Distinguished panelist discussants and dear participants, I'm very happy to be with you this afternoon and also with the Regional Center of the UNCITRAL. Joint Secretary, Ministry of Justice and Parliamentary Affairs, Mr. Kazi Arifuzzaman, and Mr. Changwan, Director, International Dispute Settlement Division, Ministry of Justice, Republic of Korea, Ms. Humaira Azam, Managing Director and CEO of Trust Bank, Mr. Yun Yang Nam, Ancestral Regional Central Legal Expert, Dr. Jamila Chaudhary, Professor, Department of Law, University of Dhaka, Ms. Jenny Hui, Ancestral Regional Legal Expert. My thanks and gratitude to the head of Ancestral Regional Center, Mr. Athita Komindr, for gracing this occasion, and all the panelists for their articulation and valuable contribution today on the theme of the webinar. Distinguished participants, BIAC is the first and the only registered alternative dispute resolution institution in Bangladesh, which provides its own rules for institutionalized arbitration and mediation to resolve commercial dispute. We are recognized by the Permanent Court of Arbitration in The Hague. ADR matters are now accepted the world over as a means of resolving commercial disputes out of court. The presence of an institution like BIAC is a vital necessity to promote local businesses as well as to invite more foreign direct investment for overall development of the country's economy while we are graduating to a developing country by 2026. Many parties have turned to us for information and guidance in the face of COVID-19 outbreak, and we are very conscious that these are challenging times for everyone. Under the awareness program, in the wake of the current global crisis and the future new norms of the handling of dispute resolution, we have been holding a series of webinars on a regular basis to reach out to our stakeholders for persistent progress of the ADR norms in the country. This is our 13th webinar of this kind. Although most parties execute contractual obligations in good faith, dispute relating to the contracts may also arise if they are not suitably managed or faithfully performed by the parties concerned. While there are a range of means to resolve such disputes, negotiations, mediation, and arbitration, and litigation, courts are often the last recourse because litigation is usually lengthy and costly, leading to increased risk and cost. In addition, these adversarial proceedings may disrupt or even cause parties to terminate business relationship. It is therefore not surprising that such businesses generally prefer more efficient and constructive means to resolve disputes than court proceedings. This is very, very important from that point of view, and we need to encourage our people, our business, and also the investors in order to bring about an atmosphere and environment where you can settle your dispute out of the court. We are proud to host this webinar jointly with the Ancestral Regional Center. A model law prepared by the Ancestral and adopted by UN Commission on International Law in June 1985. In 2006, it was amended and now includes more detailed provisions on interim measures. The model law is designed to assist states in reforming and modernizing their laws and arbitral procedure so as to take into account the particular features and needs of international commercial arbitration. This is very, very important from that point of view, and we should look into these amendments in the ancestral law. The model law is designed to assist the states in reforming and modernizing their laws on arbitral procedures so as to take into account the particular features and needs of international commercial arbitration. The aim of the webinar, inter alia, was to suggest how both the World Bank's Global Doing Business Index and the Asia Pacific Economic Forum Ease of Doing Business initiative are dedicated within the Asia Pacific region to assess and improve regulatory environments of the countries to make doing business cheaper faster and easier. Enforcing contracts, including the adoption and implementation of UNCITRAL ADR instruments, are essential components in this regard. I am confident that today's priceless deliberations by the distinguished panelists and the speakers will definitely change the existing perception and the mindset about the non-adversarial dispute settlement in Asia and the Pacific region, including Bangladesh. My sincere appreciation to the moderator of this session, Barrister Rashna Imam, Advocate Supreme Court of Bangladesh, and Managing Partner Akhtar Imam and Associates, for not only moderating the webinar through her scholastic aptitude, but also arranging this important event jointly with us. My thanks to our CEO, Mr. Muhammad Rumee Ali, and BIAC team too. Thank you all, including the registered participants and viewers of the session. And I only hope at the conclusion of my statement that we should see face to face. We should sit face to face sooner than later. Because of the situation now we are going through, it is not very good that we are passing by, but very, very important that we look forward to see each other in a gathering, in a seminar, in especially somehow we can also entertain you with immediately after such deliberations. I look forward to each one of you to see soonest so that we can exchange further ideas about how to encourage and implement the alternative dispute resolution methodology in Bangladesh instead of going to the court procedure. Thank you very much indeed. Allah Hafiz.
Thank you very much, sir.
Allah Hafiz. Thank you.
Thank you.
Ladies and gentlemen, thank you so much for joining us for today's session. It has been a wonderful session, and on behalf of Bangladesh International Arbitration Center, we thank our friends from UNCITRAL RCAP, and we thank our friends here from Bangladesh for joining us for this wonderful session. We look forward to have you all in our upcoming events, and we leave you with some information on the screen. We hope you do get in touch with us in the future, and it has been a wonderful session. Thank you so much for joining. We take your leave humbly. So do join us in our future events. Thank you so much.
Thank you very much.
Thank you. Thank you.
Thank you.
Thank you so much. Thank you.